Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Mazzucci.
Welcome, everybody, to another very exciting episode of our show. Today, we are talking to Rebecca Goldfarb. Rebecca, welcome to the show. It's a pleasure to have you.
Thank you so much. I'm excited to be here.
Absolutely. And Rebecca is an estate planning attorney and practices elder law as well. The name of the firm is Goldfarb Luu. And I've had the pleasure of talking to her prior to the show, and I'm already amazed by her personality. So this is going to make for a very exciting conversation. Let's delve right into it. We're going to be talking about something very important today, which on our show, we've talked about what is this and what is that, but we haven't talked about the operating procedures very much. And Rebecca is going to help us today and guide us essentially through what the steps are that a person has to do when they are setting up a trust and how to deal what happens when the trust is set up. So one of the first questions I have for you, Rebecca, is how should individuals begin to process the process of organizing their assets when considering setting up a trust?
Well, we get people, clients who come to us from very young people to very old people. So some people have very few assets, and that's a relatively easy process. And other people have a ton, and they're not usually very well organized. So I think one of the biggest parts of thinking about your estate plan is to get your ducks in a row is getting your assets organized. So what we do, and I don't know about other firms, but what we do is we create a simple Excel spreadsheet, and it has different areas to fill in. So the first is real estate. The second is any businesses you might own or have interests in. You can be a partial owner in something, any retirement accounts, bank accounts, other assets that might have value. They could be vehicles or collections, life insurance, all those kinds of things. And it's really just putting everything down on that spreadsheet for us. And then before our clients have a meeting with me, they have a meeting with our paralegal, Michelle, and she walks through every single asset. She tries to get account numbers. What so many attorneys do, maybe in lieu of this, I'm not sure, is they create a schedule at the end of a trust. So you've probably seen this before, where it's Schedule A, Schedule B, Schedule C. Right. And so people have their assets written there, right? It could be community property, separate property. It depends on the situation.
Right.
What this leads people to believe is that, oh, here's my trust and here's the schedule. This must mean these assets are in my trust. It has nothing to do with that, right? So it's a false sense of security when I say, okay, so what's in your trust? And they rattle it off. And then we go to look really who the owner is, and none of it is in the trust, or very little is in the trust. So I think that the problem, even with people who have trusts already, who are coming to us for a review, is they have this misconception that it's properly funded. And I think emotionally, lawyers aren't usually really in touch with the emotional part of their practice, but I'm extremely in touch, because estate planning and elder law is like 80% emotion, right? And then 20% law. So when you've gone through this whole process and you've signed your documents, you feel like, okay, I'm done. Right. And we always tell people, okay, you're almost done. The light is at the end of the tunnel. Now we have to fund the trust. So what I'm going to share are some ideas about how to get that ready for a lawyer if you're brand new to this process. But even if you already have a trust, it's really important that you review it, because I guarantee your trust was not 100% funded at the time. And if it's been a while, things have changed, right? Assets have changed. Or this in your line of work, people refinance, And
Right.
then the mortgage company doesn't put it back in the trust, but the client doesn't know that, right? And so then they're at risk for probate.
Correct.
So I
And then
think
we deal with exile petitions and things like that, which are not fun. It's better to be organized.
and I think that unless there's family drama, this is the hardest part, is like getting all this organized, right? And then I want people to have the mindset of, hey, when we need to use these documents, it means somebody has lost capacity or somebody has died. In both of those cases, someone else is stepping in your shoes, right? So if it's a trust asset and you're incapacitated, who's managing that asset?
Right.
Whoever the trustee is. If you're incapacitated, this could be a problem. That means that the successor trustee is managing this asset, right? Now, if the asset is in your name and not in the trust name, it means the power of attorney is doing that. And so it's really important that you realize as the client, when that time comes and you have a gazillion bank accounts because you have your travel account and you have your account and you have it for this rental property and you have, right? A lot of those get consolidated. So a part of this process that I think attorneys fail their clients on is not only are we getting the assets organized that will go into the trust or be the trust will be named as a beneficiary of, but also what are all your bills?
Right.
And who pays them? And are they auto paid, right? Because when we consolidate those accounts, those don't work anymore. And we don't know it as the power of attorney or the successor trustee. So there's a lot that goes into this asset bill kind of thing organization.
That makes total sense. Okay, let's take a little step back because I definitely want to touch. You gave us so many valuable information. I definitely want to touch on a few things. Okay. One of the things that I want to talk about is, let's talk about the type of assets which somebody should expect to place in a trust. Now, we all know your home. That's the easiest thing, your primary residence. You take title as John Doe, trustee of the blah, 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 blah trust, et cetera, et cetera. Okay, so we have that one, and that's kind of like the easiest one. But what about the other assets? You mentioned things, bank accounts. People don't think about those things. People may not even know. How in the hell do I put a bank account in a trust? Or what about my life insurance? And what about my collection of paintings? And what about my, my grandfather's gold watch, and things like that. So tell me, when we're doing the inventory, and I know that I'm sure you guide the clients, with your spreadsheet, but for our audience, what are the assets I need to consider when I'm thinking about funding the trust?
So you mentioned the home, which is perfect. And it's really important that people realize that just because your home is mentioned that it goes to your kids doesn't mean it's in the trust, right? So it's that deed that's changing, that's saying the trust owns it with you as the trustee managing it.
Yeah.
And we talk about a business, right? So it could be a law firm, it could be a dentist, it could be a beauty shop, it could be any kind of business, janitorial business, any kind of business.
Right.
To look at the entity of it. If it's a sole proprietorship, then we look at just the trust funding part, right? Are those bank accounts titled in the name of the trust? Because the sole proprietor is just really you, right? It's not an entity. But if we have a corporation or an LLC or a partnership, then we need to look at the operating paperwork for those different entities. In an LLC, for example, it's an operating agreement, right? In a corporation, it's the bylaws. We need to look at that and we need to say, hey, are there any rules that we need to follow to assign that entity to the trust? And then we have to follow what those rules are. If it's just you personally, there's probably not many rules. But if you have partners, there are going to be rules, right?
Right,
and
absolutely.
So we need to do that. We did a trust administration that lasted for way too long because the person who died was not our client. The trustee was our client. And when they did this, when she did the trust and did the funding, and she was a CPA, so the trustee thought, oh, she's got to have everything organized. Her business assets were not assigned to the trust. So I actually went to her house because I wanted to avoid probate, right? I went to her house and I looked through boxes of it, just looking for this one-page assignment. I couldn't find it. So if you have over 184,500 outside of a trust, meaning the trust doesn't own it, meaning it's not jointly owned with someone else, meaning the trust isn't a beneficiary or there isn't another person as a beneficiary, then it's going to trigger us to go to court. One of the main reasons people do a trust is to avoid court. So this funding element often is overlooked by both lawyers and clients is critical to the success of your trust working the way you expect.
That makes sense.
So that's, if you have life insurance, unless you are doing advanced planning with an irrevocable life insurance trust, but if you just have a regular old revocable trust and regular old term or even a permanent policy, the beneficiary of that life insurance trust, the beneficiary of that life insurance policy can be the trust. And if you have minor kids, right, or just kids under 30, because remember, one's frontal lobe of their brain is not fully developed till between 25 and 30, right? So, and it's also a way of asset protection. It's, you get in a car accident, right? And the PI attorney is going after your assets, but if it's held in trust for you, then they can't go after it if you're not the trustee. If you're in a bad relationship, that spouse or that girlfriend or boyfriend isn't going to go after anything, right? Because you don't have control over it. Somebody else is the gatekeeper. So we put the beneficiary of those life insurance policies as, it could be the spouse first and the trust second, or just the trust right off the bat. So, and then you think about other, a new thing. Retirement plans, same thing. You have to be the owner of a retirement plan, but you want the trust to be at least the second beneficiary as the backup. The spouse can be the first. Right.
Okay. That makes total sense. What about personal property? Valuable personal property.
So you just have to interrupt me when, okay. Personal property. So we do, I think all lawyers do this, a personal property assignment, right? So in your trust, it's like, whatever, 50 pages, right? And then there's this assignment of personal property. It's just a one-page thing. So you're assigning all of that. But what's really important, and this is a teeny bit off topic, but so important, is that you want to make sure if there are special things that they are specifically gifted to particular people. Do not ever say, oh, it goes to my kids all equally, they'll figure it out. Because I can't tell you, I met a probate judge about 15 years ago at a breakfast. And I said, hey, can you tell me, I'm just curious, I was relatively new at this. Can you just tell me, what is the smallest amount that you have seen litigated? And I mean litigated, not that it just triggered probate, litigated, right? $10,000. Now, know these attorneys charge, right? And I said, is it mostly men or women? And without even hesitating, he said women, right? So it's like people will fight over grandma's green bowl. It is so important to ask kids, don't make the assumption, ask your kids, what do you want? And then name that as a specific gift.
Yeah, you know what? It's funny. It reminded me of something. I'm going to share it with my audience. I was watching an episode of a TV show, and the guy was like, I have to realize my mortality, whatever. So he gathers his family together, and he says, here's are your stickers, your blue, your yellow. Put stickers on whatever you want. And it was very funny because, in the end of the episode, he's putting on his robe, and there's a sticker on it. It's like, they really took me seriously.
You have to use tape, though, because we've had client situations where they put stickies on it and then the sticky falls off. So you got to put tape with the sticky.
Yes. Okay, this is very good. Everything you share with us is extremely informative. Let's talk about the mechanism through which individual can access and manage assets held within a trust during their lifetime. So what level of control do they retain? Because I think there is a hesitation. Here's one of the things that people are hesitant about. I'm putting it in the trust, and then my kids are going to evict me from my own house when I'm old. There is a lot of that. There is a lot of that misinformation. So that is not the case. So let's talk about the control and what control is retained and how it works.
So as the grantor, the person who creates the trust, and the trustee, the person who manages, and the beneficiary, that we have all three of these roles when we create a trust, right? So I own all of the assets in the trust as the grantor of creating this, right? And then I manage all of the assets. So while I have capacity, and this is the big question, while I have mental capacity, I am 100% in charge of these assets, of putting them in, taking them out, selling them, 100% the same as if I didn't have a trust. I am also the lifetime beneficiary of this trust. Now, there are advanced tax planning trusts where this is not the case. So I am only speaking about revocable living trust.
Right.
So I am the lifetime beneficiary. So it has to benefit me. All the assets in there have to benefit me. Now, let's just fast forward. I become incapacitated, right? Dementia, whatever, accident, whatever. Then I can't be the manager anymore. Then I am trusting my successor trustee to manage those assets for my benefit, because even if I'm incapacitated, I am the lifetime beneficiary of that trust. So when you say that, theoretically, you know, there's the theoretical, this is how it should work, this is what the law says, and then there's the reality of how it works. We focus, obviously we know the former, but we focus on the latter. What is the reality? Because theoretically, it doesn't always work that way, right? So with the example that you gave, kids are now the trustees, right? Or we very rarely ever say you're co-trustees. We pick one and then the other, because these financial institutions more and more are not accepting co-trustees, co-agents, and powers of attorney. So we say, okay, who's next in line? Now, that person is the person you are trusting, just like with a power of attorney, to stand in your shoes and act solely for your benefit and not his or her own. If you have a shred of doubt, I don't care what your relationship is with that person, don't make him or her the successor trustee, because they do, see, I was going to swear, they do right? To old people all the time, it happens. So you have to be really certain. And if you're not, we need to set up other mechanisms so that there's safeguards in there to protect you. We are huge advocates of our elder population. This is, you know, a big love of ours. So we see this all the time.
And you know, another thing that I'm going to take the opportunity to mention it, you also practice elder law, and I think that we should have you back on the show to discuss just elder law. So for the time being now, let's talk about taking assets in and out of a trust. So you do put the asset in a trust, and now we have explained to our audience, you don't lose control, don't worry about it, you know, blah, 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 and etc. That's very important things. But now let's say I change my mind. You know, I have a bunch of assets in my trust, and I was like, you know what? No, I don't want this in there. What are the mechanisms? And how, first of all, is it possible to take stuff out of a trust after you put it in a trust? I guess that's the simple question.
It is, as long as it's a revocable trust, you could do whatever you want. Take them in, take them out.
Great. So how does the process work when somebody says, Rebecca, take my house out of the trust?
Most people don't do that. I don't know that we've ever removed a trust asset for a client. We, as the lawyers, deal with real estate and businesses, and clients deal with all the other financial assets. But they might take an asset out of a trust if they're selling a business, right? Or something like that. But really, it's just paperwork, right? Depending upon what the asset is, it's just filling out new paperwork. And so if it's real estate or business, you might need a lawyer to help. But if it's any other financial asset, the financial institution itself, or your financial advisor, or CPA, or the lawyer, you know, all kinds of people can help with those forms.
Got it. Perfect. That makes total sense. Now, let me ask you a question. The trust, you know, once you organize the trust, you make a decision which is in a point in your life. Now, we know that life changes. People may get divorced, new children, grandkids. I mean, things change. So how do you help your clients update their plans so that it reflects the current situation? You know, because, I mean, if somebody does a trust when they're 30, at 80, most likely things will be different. So so that I don't wait until I'm 80 to make the changes or when it's too late? How do you assist your clients in keeping things current?
This is a really good question, and I hesitate to answer because we do it differently from everyone else.
Oh,
So
you're saying this is the secret sauce? I don't want to share.
I wish everyone would do it the way that we do it.
Right.
But it is a secret sauce because people don't, that lawyers don't see the value in it, right? And I think they don't see the value in the way we do it because you make less money, quite honestly. And we're not in it to make money. We're in it to serve our clients in the best possible way. So what we do, and then I'll tell you what I think the norm is, just from what I hear from other lawyers and clients who come to us, is we set up our plans in an extremely detailed, more detailed. Clients who have come to us from other attorneys are like, no one's ever talked about it. And I'm like, I know, it happens all the time. So in an extremely detailed way, we dive into layers and we have backup plans because stuff happens, right? And so but let's say it wasn't that something failed per se. Plan A didn't fail, so it's great that plan B is there, but I've just changed my mind, right? So what we do is, as a part of our flat fee, it's a life plan. So anytime a client has a question, a concern, they need a resource, right? They want to talk about whatever, they just call us, and it's just part of our life plan. So we know when it warrants an update or not, right? And then every few years, we used to do it every year and nobody would take us up on it. So now the sweet spot seems to be every 5 years. We offer a maintenance meeting and we say, here, now's the time, you review it. Let's come to the meeting. Let's talk about it. Let's see if it warrants any updates, right? And we'll go through each document and make sure everything is funded properly and nothing has changed along the way. So we're really hands-on, but that's not the norm. And then we do charge if we're doing updates because some of them are super simple. In which case we probably don't, when it's more time consuming to generate a bill than to just do the work, we just do the work, right? But if it's going to take some time, then we bill our clients at that time. But we're super fast, so it's not that much. The majority of lawyers, I believe, rely on the client to know when to come back. And that's why so many plans fail, right? My definition, and this is just what I want, I wish every lawyer had the same definition. I want these plans to honor our clients' wishes. They have to avoid court and they have to maintain family harmony. And yet 99% of every plan that comes to us will fail in one of those ways. So it's incumbent upon us as lawyers to be the educators, to be the counselors, the guides, right? To direct our clients. If a client came to us and said, I want my 3 kids to be co-trustees, I would say, absolutely, hands down, no. And we will educate them enough so that they realize it. But in the extreme case, if they said, well, that has to be, I would say, I can't help you because I know the plan is going to pull family members apart. So I know that's sort of off topic, but
no, it's not. You know what I was actually thinking? How inspiring. I really appreciate it. First of all, death is a subject matter that, it's always tiptoed around when it comes to family, et cetera, et cetera. So what your firm does of being there, with your fee, we are here for you for the lifetime, that's a peace of mind. And that's worth it for sure. A lot to somebody. And the fact that you update and you help, you assist and you guide, I think this is what it's all about. I do the same thing in my business. It's to put it, it's important. Sometimes the client do not know what they want. We do what we do all the time. So if somebody has an idea, we have to tell them, look, in our experience, when you do this, this, and this is what happens. Right. I've done it many, many times before, and I can tell you that 90% of litigation is when people have co-trustees or whatever the situation may be. And that really is what distinguishes, an advisors between somebody who's just providing a service. So I think that what you said, it's very important. So I appreciate that. Thank you for sharing that with our audience. That's great. Let's talk about your journey. This is something that always fascinates me, and I think it's important. When you were a little girl, did you want to be an attorney?
So when I was 12, I decided I was going to be an attorney.
Wow.
My grandparents on my mom's side showed me their trust.
Okay.
And said, I'm the only grandchild, right? So I had special relationships with both my grandparents, which is probably why I do elder law, because I love them. Anyway, they brought me their trust and they were like, here's what it says after we're gone. And I said, doing it that way is a huge mistake, because they had a son they didn't deal with, they didn't have a relationship with, and they were making him a partial owner of the house. Mm-hmm. And I was like, Grandpa, you can't do that. You got to go back to your lawyer. So over like a few years, I think when I was like 15, they finally did it. They changed it to give him some money, but don't force people to work together who can't work together now, right? So I felt like that was important. So then fast forward, I was a paralegal in a law firm after college, and then I knew I wanted to go to law school, but I didn't know exactly. So I went to do environmental and animal law. I was like, this is my passion. This is who I am. And then I realized after I got my specialty certificate and all that, like, oh my God, this is all litigation. I'm not a litigator, right? I want to hug my clients. I want them to tell me they love me. I want to love them, right? This is not for me. So I met Din, my dear friend and law partner, in 2005. And in 2008, we decided to sit down. And by the way, on our website is our birth story. We actually did a video together of our birth story.
Oh, that's awesome.
But this is the short version. So we printed out a list of all the areas of law one could practice, and went out to dinner and went through each one. What are we interested in? What will feed our souls? What could have a marketing plan? All of that. And estate planning was the only thing that would do three things. We could really make a difference in people's lives. We could have lifelong relationships, and we didn't have to go to court. And there's no other area that you can do that. So we were like, I guess it's a state. I didn't even take wills and trusts in law school. I wasn't going to do this, right? So then we spent a year or two like learning how to do everything and all of it. I guess that was in maybe 2007. So in 2008, we were like, okay, here we are. So, and then we added on elder law, because if we live long enough, right, everyone's going to need elder law in some capacity. So that is our
That's
story.
wonderful. Thank you for sharing that with me. All right. Before I let you go, I like to do my exercise at the end of the episode, which is basically, I have a list of 30 questions. I would love for you to pick a random number, and I will ask you that question. So you're responsible for the questions I'm going to ask you. Oh. Go ahead.
Wait, it's between 1 and what?
1 and 30.
30. Well, my favorite number is 117 for some random.
Okay.
So I'm going to say 17.
17. Oh, I like this one. Why were you given your name?
I want to tell you why I gave my daughter my name, because I know that.
Good.
So I'm half Jewish, and so in the Jewish religion, you name someone after someone else who has died. And so there was a grandmother on that side who was named Rebecca. And I think my parents just both really liked it. But I will say they were major hippies, and they never used their middle name. So they were like, she doesn't need a middle name. So I don't have a middle name. So it's just Rebecca Goldfarb is it.
Because of this story, I'm gonna share a story. This is why I love these questions. I also never had a middle name, because in Italy we don't use middle names. But when I married my wife, she gave up her last name, which is Baker. So I took that as my middle name. So my legal middle name now is Baker. So that's a funny story, because people ask me, it's like, you're from Italy. What is that Baker doing in the middle? Now you know the story. Okay.
You really love baking.
Yeah, exactly. Now let me ask you this question, because now you brought it up, so we need to know, why did you give your daughter your name?
So her name is Taryn Willow Dugal. Wow. And we wanted to honor the Jewish side, so we picked something from each of our cultures. So we wanted to honor the Jewish side, and my grandma Thelma was the most recent person who died, so we knew it had to be a T name.
Okay.
And on my mom's side is Irish and Scottish, so it had to be a Celtic name. So that's where it's from. My husband is Oliver, and so he was named because his mom loved the olive tree. So we had to pick a tree to honor her because she's passed away. So we both love willow trees. So that was it. And then he's also East Indian. And so she has his last name. So it's all of us. But then the funniest part is, and the cutest part is, during the pandemic, out of the blue, we have no idea why, she was like, my name's Snowy. That's what I want. So now everyone at school for 3 years knows her as Snowy. No one knows her as Taryn.
Wow.
So, but now she's starting to tell new people her name is Willow. So, you just got to go with names as they come to you, I think.
That's wonderful. That's wonderful. Well, it's been so great to have you on the show. Thank you so much. It's been such a pleasure. Stay on. I'm going to do my sign off, but you stay on so we can say our own goodbyes. Everybody, thank you so much for joining us. One more thing, actually, Rebecca. There's going to be your contact information in the show notes. But what is the best way to get a hold of you?
So people can call our 800 number, which is 800-489-1984. You can visit our website, which is goldfarbluu.com. And then I think you can do contact us at goldfarbluu.com as well.
Okay, fantastic. Thank you so much. It's been such a pleasure to have you on the show. Thank you, everybody who's joined us. And we'll see you on the next episode. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Mazzucci is a licensed real estate broker in California, DRE number 020544763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.